Test 1 2 3 1 2 3 1 1 1.
Good morning, ladies and gentlemen. Our first case for argument this morning is Cannon against Phillip. Mr. Parr.
Good morning, Your Honors, and may it please the court. Keith Parr from Buchanan, Ingersoll, and Rooney for Mr. Cannon, Antron Cannon. This case gives this court the opportunity to restore Antron Cannon's rights to have a jury of his peers decide his civil rights claims. I want to focus on three things. First, the material facts that should have been credited in Antron's favor under the Tolan versus Cotton case, 572 U.S. 650, 657 to 659. The second thing I'd like to focus on is why it is important that a jury hear Antron's case. And the third thing I'd like to focus on is who would be on that jury. To begin with, the warrantless entry into his home. The summary judgment standard requires Antron and Sarah Taylor's testimony to be credited. Their testimony is consistent. Just like in the Tolan versus Cotton case, the Tolan and his mother's testimony were consistent. There is a factual dispute. It should have gone to a jury.
Factual dispute about what, concretely?
Okay, concretely, both Antron and Sarah testified that they were naked in Antron's house, that they heard knocking, but that neither of them answered the door. They testified that they were having consensual sex when they heard the knocking.
Why is any of that material? The question facing the officers when they come in is what they know. So what material dispute is there about what the officers knew?
What the officers knew is different depending on which officer it is. They received CAD notes, but not all of them, if any of them, actually heard the 911 tape. One of the officers, Ranchamp, testified that...
Why is that material? There's a doctrine of collective knowledge for police response to any call, right? The question is whether the officers behaved reasonably in light of the facts known to them. So you need to identify a material dispute about what facts they knew that would draw into question whether their behavior at the time was reasonable. Well, you need to focus on that, counsel.
Yeah, the argument that the defendants have made is that there were exigent circumstances. There were not exigent circumstances, and that is a fact issue for a jury. Antron and Sarah were having consensual sex.
You need to focus on what they knew at the time, and not what the plaintiff said later.
Ranchamp testified that the CAD notes were insufficient to support exigent circumstances. So what they knew is they were in the curtilage outside of his house. It was dark. It was a nighttime warrantless entry into the home. It was dark at the time. What did they know? They knew nothing. If what got them there, which was a swatting call, isn't sufficient, then they knew nothing when they were outside the home.
Counsel, what is your support in the record specifically that this was a swatting call? Because I listened to the 911 calls with the aunt and the cousin, and they sounded really concerned about the woman who they thought was being beaten in that home.
The testimony is unequivocal that Antron and his cousin had an argument, a heated argument. The cousin, who I don't even know his last name, the cousin left the home, and we don't know exactly what time he left the home. But that is a swatting call.
So it's speculation on your part.
No, it's something that a reasonable jury should be allowed to consider to determine what was the basis for the phone call. When the dispatcher asked the aunt what his name was, she didn't even know her own nephew's last name. She then
I want to
calls
direct
him.
you back to Judge Easterbrook's questions,
Mm-hmm.
because irrespective of what the cousin's motive was, there were the calls, right? And the officers didn't know if the two had fought earlier. They have to go on their reasonable belief. So why does that even matter, what the cousin's motive was?
Well, they need to do an investigation.
But doesn't the exigent circumstances doctrine state that police can't meditate on whether they can't meditate on whether this was a swatting call or not when they have information that a woman is being beaten?
They can go get information. They could have contacted, no police officer contacted the cousin. No police officer contacted the cousin.
The dispatcher did, though.
The dispatcher did, and the cousin said that he wanted to remain anonymous, that he did not want to get involved, that he couldn't give permission to enter the home, and that he was talked into it by the dispatcher.
And so you're not disputing the material facts that by the time the officers responded, the officers on the ground had information that there was a domestic violence incident going on, and a family member was concerned.
They had hearsay. Yeah, that's what they
You're
had.
not disputing that material fact.
Not
You're just saying
that they
for exigent circumstances.
For
they need-
exigent circumstances, that's a separate thing, and that's what a jury should decide.
the
that's
jury
why this-
decides exigent circumstances.
Yes, it should go to a jury. The facts surrounding the circumstances should go to a jury. Yes. The Civil Rights Act of 1871 was enacted to protect individuals who were being harassed, and sometimes by local officials. It was passed in the Reconstruction era after the Civil War, and Antron is a African American man. Sarah she appears to be Caucasian. The decision that was made by these officers, I mean, after they entered the home and they saw that they were naked and having consensual sex, why didn't they leave? I would have left. Maybe, I think if you did a poll of a jury, I think a lot of other people would have left. They wouldn't have done what these officers did. They wouldn't have put handcuffs behind him without pants on, had a female officer standing right at him, looking at him. They wouldn't have done that. They wouldn't have had another officer come 20 minutes later, take her outside and bring her inside, take her top off, take nude frontal pictures of her breasts, which showed no injury. They wouldn't have done that. Why isn't that a material fact? Because it is. They called paramedics to the house. What did the paramedics do? They evaluated Antron. They didn't evaluate her. If she was a victim, why wouldn't you have the paramedics look at her? I think that's important. I think a jury would find it important. And who would be on a jury? I will tell you that it's likely that people that would be on the jury would not be people that wanted this to happen to them. I'll yield.
Thank you, Mr. Parr. Mr. Kujawa.
Good morning. May it please the court. Michael Kujawa on behalf of the defendants at Belize, City of Aurora, and officers Phillip, Grandchamp, Driscoll, Pineda, Rodriguez, and Howe. This court should affirm the district court's grant of summary judgment in this case because the district court was correct. There are no issues of necessary material fact. And counsel's argument here just underscores that, because all of the arguments that he is making are about extraneous, immaterial, and unnecessary facts to the actual issues that the district court was deciding in this case, which is exigent circumstances and probable cause. The undisputed facts, material facts that are necessary, shows that there was clearly exigent circumstances that would existed for these officers when they got to that house to justify the warrantless entry into that house. And just as clearly, those officers had probable cause to arrest Mr. Cannon based upon what they learned after they got into the house and the statements made to them by the victim in this case. So what are those exigent circumstances? And first off, counsel talks about the Civil Rights Act and harassment, and it was designed to stop people from being harassed. No one was being harassed in this case. The Aurora Police Department didn't go there uninvited or uncalled. They were called to this house by plaintiff's own family members. It was his Aunt Ray, based upon information she received from his cousin Jonathan, who had been in the house shortly before the call was made, who called to report this incident. And what did our officers know at the time that they got to that front door? They had heard the 911 call and the information from Aunt Ray, who was not an anonymous caller, by the way, who gave her name and identified herself as someone who had a family relationship with the individual that she was calling on. But she said that Mr. Cannon had lost his mind, that he was drunk and violent, and that he was beating up a woman in the house. When they got there, they heard yelling from inside the house. Whether that is yelling during some type of consensual sex or not is immaterial. They still heard the yelling, and that matches up with what they're hearing in this 911 call, the facts that they received from that family member who identified herself. And then someone talks to one of the neighbors and says that no one has left the house since they've been out there. Once again, another fact which would lead them to believe that the individuals who have been reported in that house and involved in this domestic violence incident are still within that house. The 911 call alone is enough when we have an identified family member who's making the report. And none of it is hearsay for an exigent circumstances analysis or a probable cause analysis. And so they clearly had exigent circumstances which existed to justify their warrantless entry in the house. The only disputed fact that might even be considered material is the testimony of a couple of officers who said Cannon, when they knocked on the door, after a while, Cannon opened the door, yelled some things at him, and told him to get a warrant and slammed the door. Cannon, of course, and the victim dispute that, but that is not a material fact because, as Judge Kennelly looked at, he said, if there's a disputed fact, I'm going to put that in. And so throw that one to the side. If Cannon never answered the door, the exigent circumstances still existed based upon all of the collective knowledge of those officers on the scene at the time. Then let's get to probable cause. So probable cause is clearly there based upon the interview done of the victim, who says that he was choking me to death, that he hit her and bit her, that he would not let her leave the house, and that she thought he was going to kill her. Now, when she gave her deposition testimony months, if not years later, did she tell a different story? Sure she did, but we have video and audio of her statement given to the police that night. And that statement clearly demonstrates and establishes probable cause to make the arrest of Mr. Cannon in this case. So Judge Kennelly got it correct when he determined that there were no necessary material facts, that exigent circumstances existed, and that there was probable cause to arrest Mr. Cannon. The only remaining issue before this court is the assessment of costs against Mr. Cannon. And Mr. Cannon's argument essentially says, I'm an indigent plaintiff who filed this case pro se, and it was represented by appointed counsel, and it would be inherently unfair to award costs against me. Not privy to what communication or what information was given to Mr. Cannon, what the consequences or ramifications might be of someone who files a lawsuit and is not the prevailing party, and what the statutes are regarding costs. But Mr. Cannon brought this suit. He had his opportunity to litigate it fully. There is no merit to it, and the rules apply to him as a pro se litigant just as they do to anyone else. And so, just like the grant of summary judgment that Judge Kennelly awarded to the defendants in this case, the award of costs should be upheld as well by this court. Unless the court has any questions of me, I will conclude my argument. Thank you.
Thank you, counsel. Anything further, Mr. Parr?
Yes, Your Honor. The right, as I said before, to determine the facts is for a jury. Counsel conceded that there is a factual dispute about what took place at the house. Said that they testified or said in a supplemental incident report that Mr. Cannon opened the door, yelled at them, told them to get off his property and to get a warrant. He testified, and Sarah Taylor testified, that neither of them answered the door and neither of them did that. There was no yelling and screaming. And the best testimony that they have about yelling and screaming is that they don't know who was saying what. They didn't say anything about her screaming, nothing at
Thank
all
you,
about her
counsel.
screaming.
Thank you, counsel.
Okay, thank you.
The case is taken under advisement. We'll hear argument next in the case of Price against Kari Scharf Trucking. Mr. Walton.
Good morning. May it please the court. Mark Walton on behalf of the plaintiffs, appellants, William Brokaw Price, Sharon Price, and their company Windfall Properties. This is a breach of contract case. Comes to this court following a jury verdict against the plaintiffs on their breach of contract claim. Plaintiffs filed a 50B motion following the trial. District Court Judge Mim denied that motion. What we're asking the court is to enter judgment as a matter of law on the issue of liability for the breach of contract, and then remand just for a trial on the sole issue of damages. So the plaintiffs, our position is that there's no evidentiary basis for the conclusion that the defendants did not breach the contract. The issue of liability never should have been given to the jury. The reason for this, the contract at issue, as the court knows, this was a sand and gravel mining operation in McLean County. The contract at issue was effectively a lease. Kari Scharf Trucking is the defendant that was the mining operator. The Price family owned the farm property, allowed Kari Scharf Trucking to engage in mining operations on the property. The critical piece for the contract determination is that it had a defined term. And like any lease, it defined a period of time during which the defendants could make their operations and extract sand and gravel and sell sand and gravel from the property. And then at the end of the term, much like any lease, they had to yield possession back to the property owner. Okay? So the issue that arose in this case is the fact that all of the conduct that really formed the basis for the trial is conduct that occurred after the expiration of the term. There's no factual dispute. In fact, there were admissions at trial from Mr. Scharf, the owner of Kerry Scharf Trucking, that the contract term expired December 31 of 2010. Okay? And the contract required certain conduct, certain performance of the defendant by the end of the term, and that's what's critical. The contract required compliance with all laws and permits. The primary operative permit at issue in this case, and it was discussed extensively during the trial, is a special use permit issued by McLean County. That special use permit required reclamation of the property at the end of the mining. The contract also, in Article 14, required work that Kerry Scharf's own engineer described as reclamation work. Building a bank of the lake, distributing material around the site, and grading the site. That's Don Adams' testimony. And this is work that had to be done at the end of the term. So there's no dispute that that work was not performed. It wasn't done by the end of the term, December 31, 2010. It's all the way into 2016, 2017, and 2018 where the parties are working toward, with McLean County, trying to get Kerry Scharf Materials to belatedly perform this work. Those settlement negotiations, which in effect what they were, the prices were working to try to get the mining operator to perform that work, even though it was past due. And those efforts broke down, they failed, so the lawsuit was filed. What's important, I think, for the court to understand is that the jury's verdict allows the mining operator to escape responsibility for cleaning up and reclaiming the property. And, it's important to understand, this is a business. A mining operation is like any other business, okay? And reclamation costs money, okay? When you put the reclamation work off to be performed at the end of the contract period, you don't have any offsetting income to pay for those costs.
I don't understand, counsel, why you think this contract is so clear that evidence is irrelevant. The very last sentence of Article 14, the one you're relying on, says reasonable plans and directions of price as to the distribution of said leftover materials shall be complied with at Scharf's sole expense.
Correct.
So we need to know what all of those things are, and you can't find them by staring at Article 14.
You cannot, but you also can't ignore the limited term of the contract from Article 2. And that's where I believe the mistake by the district court is that in order to give effect to every provision in the lease or the contract, you have to give effect.
There are two things that are clear in Article 14. One is, at the end of 2010, all equipment and improvements remain the property of Scharf.
Right.
And the other is, Scharf has to comply with reasonable plans and decisions of price.
Correct.
So we need to know what those are. You can stare at Article 14 until you go blind without finding out what those directions are.
But Article 14 does not, Your Honor, require Price to give direction. It just says that Scharf will comply with directions given by Price. It does not say until Price gives direction, the term of the contract is indeterminate.
There's not a question about what the term of the contract is. The question is, what are the obligations of Scharf? And there's only one thing, there are two things in Article 14 that read on that. One is everything still belongs to Scharf, and the other is Scharf has to follow Price's directions.
Well, sure,
You see the problem. If you think Article 14 solves everything about this case, it's fantastical. It doesn't.
Well, I don't think that it's only Article 14, Your Honor. What I would point to is Article 9 that requires compliance with the permit. The permit required the reclamation work, the final reclamation work, to be completed at the time the mining operation was closed to operation. The testimony at trial clearly demonstrated.
No, you can't talk about testimony at trial because you are arguing that there should never have been a trial and that everything is established clearly on the face of the contract.
True,
That's
but
what I don't understand.
well,
I can see why a trial was needed. I can't see why there's nothing beyond the words written in this contract.
Well, based on the factual admissions from the defendant that the mining operations ended in 2006 and that nothing happened on the site after May of 2009.
Counsel, those are not words in the contract. They are extrinsic evidence which you say shouldn't exist. To prevail on this appeal, you have to persuade us that the written words of the contract are all we need to know. And I don't see how you can do that. That's what I'm saying.
Okay. You've got the written contract, but you also have addenda to the contract, again in writing, that extend the term. So all we're asking is that the court give effect to the written term of the contract and give effect to the fact that the contract only allowed access to the property during the operation of the term. You look at the contract, it's two written addenda, and you get to the date of December 31 of 2010. There's nothing outside of the contract that extends that time period past 2010.
Counsel, did you argue below that CST violated any continual obligation to reclaim as the project was going on?
We did. We certainly argued that to the jury. But again, at the end of the day, if they did it while they went, then the final reclamation would be far less burdensome and time consuming. But really the problem is they didn't complete the final reclamation, and they certainly didn't complete it in time. So really we're asking the court to give effect to the term as extended in those contract addenda, which are joint exhibits 36 and 37, and rule that the defendants breached the lease as a matter of law and remand for a trial on damages. Unless the court has other questions, I'll yield.
Certainly, Mr. Walton. Mr. Scheib.
Your Honors, may it please the court. My name is Jonathan Scheib, and I represent the cross appellants, Kerry Scharf Trucking Incorporated, or CST, Kerry Scharf Materials Company, and Joseph A. Scharf. The essence of this case is that Joseph Scharf tried to maximize royalties for Bill and Barbara Price, and that was specifically due to a May 16, 2005 request from Bill Price that these stockpiles of sand that had previously been pushed into the lake as part of continuous reclamation no longer be pushed into that lake. Instead, Bill Price asked Joe Scharf to continue to try to sell that sand as much as possible to maximize the financial benefit not only for Bill and Barbara Price, but for Joe Scharf. Because Joe Scharf agreed to follow Bill Price's 2005 directive to not push those sand stockpiles into the lake, he was forced to spend an enormous amount of time and money defending allegations of trespass, conversion, and breach of contract. Again, all because he followed the May 16, 2005 directive of Bill Price to keep that sand and sell as much as possible. In 2010, when counsel argues that December 31st, 2010 should have been an automatic ripening of a breach of contract, Bill Price wrote another letter to Joe Scharf asking his opinion about what to do next, whether they should continue to sell more sand, whether Joseph Scharf should buy the pit from them. But ultimately, Bill Price died, and they were unable to come up with any plan moving forward for those sand stockpiles. So Joseph Scharf did what any reasonable person would do. He took the plans and directions he got from Bill Price, and he continued to do right by Bill Price's request. He kept the sand stockpiles on the property and tried his best to continue to sell those sand stockpiles. That's best seen by a 2014 royalty payment to Bill's widow, Barbara, of approximately $5,700. In 2016, CST was completing reclamation work. They were attempting to complete the reclamation work, and that was only 1 month after Brokaw Price, Bill Price's son, finally gave explicit instructions to push the sand stockpiles into the lake and complete reclamation. So when CST and Joe Scharf showed up on the property to complete reclamation, they did just that. They worked on completing reclamation. There was testimony at trial that the east end of the lake and the south end of the lake had already been reclaimed as necessary per the contract and all applicable permits. The west side of the lake, where there was a drainage issue, and the north side of the lake, where the sand stockpiles sat, had not been completed. As the district court found, you could not complete reclamation so long as those sand stockpiles were on the property. That was part of the reclamation process, is getting rid of those sand stockpiles. So when CST showed up, they were kicked off. Brokaw Price stopped the work with a cease and desist letter in 2016. Quite a bit of negotiation and talk with the county from 2016 to 2018 happened, and an amended reclamation plan was put together and signed on April 30th, 2017. Unfortunately, Brokaw Price did not allow reclamation to continue at that time, and not until February 14th of 2018 did he write what was a permission letter to say you can go forward with all of the work outlined in the amended reclamation plan. Now, the jury found specifically that Joe Scharf had a contractual right to be on all areas of the property where he was trying to complete the work that was stopped 3 separate times. First, from the cease and desist letter, and then 2 more times in 2018, both in June and then in September again. And those were uncontested facts at trial. The jury found that Joe Scharf had not trespassed, that he had not engaged in conversion, and had not breached the contract. All of the facts in the law support that. What is not supported by the facts in law is that there's any plain language in the contract that gives a time of performance for reclamation. That's most clearly seen because the word reclamation is not mentioned 1 time in the entire contract. It's only incorporated into the contract through Article 9, which is various state and local permits and orders. And that reclamation was brought in through those orders under Article 9, which does not have a time of performance. Again, the jury found that a contractual right existed, and this leads us to a very important issue that the cross appeal rests on. Whether a manifest error existing in the lower court's summary judgment findings can support denying attorney's fees solely on the basis of that manifest error. Again, the jury found by clear and convincing evidence that CST had proved that the contract and any incorporated responsibilities from the amended reclamation
Was
plan.
the jury charged that the standard of proof was clear and convincing evidence?
For that particular issue, that was brought as a defense to trespass to the jury, and that was under clear and convincing evidence.
Why?
Why was it clear and convincing evidence,
Yes.
Your Honor, versus...
This is civil litigation.
Yes, sir. So the standard to prove trespass, based on the jury instructions conference with counsel, myself, and the judge, it was determined that as these were presented as affirmative defenses, clear and convincing evidence was the appropriate standard. So while the jury initially found that Mr. Scharf may have trespassed, they found that that contract gave him a right to do the work he was doing, and that was directly at odds with the summary judgment findings. But there's more issues with the summary judgment findings. First is that the lower court had 2 diametrically opposed findings when they both let the primary breach of contract claim survive and then extinguished the counterclaim, and that's the real issue on attorney's fees. The court found that on the primary claim, some evidence that the drainage work was part of valid reclamation work was shown, and that's how he let the primary claim survive to trial. But on the counterclaim, he found that CST had not pointed the court to sufficient evidence in the record to demonstrate that in 2016 through 18, the contract required that they be permitted to enter onto the farm tract to build large trenches. Because those two findings are diametrically opposed, that in and of itself should be considered a manifest error. It also, as an evidentiary prediction of the lower court, was completely superseded by the actual facts found by the jury in that defense to trespass. Again, that the contractual right did in fact exist. They had all of the facts and information in front of them, and instead of making a prediction like the district court needs to do for a summary judgment finding, they had all of the facts before them, and they found that that contractual right existed. While of course that wasn't framed to the jury as undoing the motion for summary judgment, in effect, because they found the actual fact of that contract controlled the work, it means that one of the two findings from the lower court was an error. And the fact that those two findings were diametrically opposed is what creates the manifest error. Again, a manifest error is plain and indisputable error where it disregards credible evidence. It can only be speculated about what the district court did with the evidence, but the fact that it came to two separate conclusions on the different claims only shows that he got it wrong on one or the other. They both can exist because it controls the same work: drainage work, reclamation work, and this was all mostly work on the farm track. So this was the western part of the property where a lot of this work took place and was the initial problem when trespass was alleged. So as those two incompatible motion for summary judgment evidentiary predictions were superseded, we have to look to the case law and the underlying principles in the case law. Now, the court rejected on a Rule 59 and Rule 60 motion that its evidentiary prediction should be superseded by the actual facts of the jury. However, what the court didn't do was ever make a finding about whether a manifest error existed. And that is the abuse of discretion that the court had, where they made an error because it didn't even look to see if there was a manifest error. And because that manifest error exists, it should have been overturned. Attorney's fees under the fee shifting provisions say successful enforcement of the terms and provisions of the contract. Mr. Scharf was on the property 3 separate times trying to finish the work that was issued in this case, and he was thrown off. He followed directions and said, if you don't want me on the property, I will leave. He was then sued for breach of contract for not completing the reclamation work. Under the fee shifting provision, he was trying to do what was required under the contract, and because the appellants threw him off the property.
Thank you, counsel.
Yes, sir. Thank you.
Anything further, Mr. Walton?
Yes, just on the attorney fee issue, counsel laid out a reason why he could have and perhaps should have appealed the the grant of summary judgment on the counterclaim. The undisputed fact is he did not. They admit that they did not. It's not part of the appeal. In the absence of a successful counterclaim, fee provisions like the one at issue in this contract do not entitle to a party who successfully defends a breach of contract case to attorney fees. We've cited the Illinois case law. What counsel is effectively asking. Thank you.
The case is taken under advisement. Our third case for argument today is Amazon Services against the National Labor Relations Board. Mr. Stolzenbach.
Good morning. May it please the court, Brian Stolzenbach on behalf of Amazon. This appeal presents two combined cases involving two separate petitions for review of a National Labor Relations Board order, two separate but related decisions. In the first decision, the board found that a boilerplate brief legal disclaimer on an off-duty access policy violated Section 881 of the Act. In the second decision, the Labor Board found that Amazon breached a settlement agreement settling prior cases about a different off-duty access policy, and that because of the breach, Amazon was subject to a default judgment in those previously settled cases. Of course, the primary alleged breach was the alleged unlawful disclaimer in the first case, and that's why they're related and consolidated before the court. If I could, I'd like to start by discussing the disclaimer case, since it's central to both. The off-duty access policy that Amazon published on June 30th, 2022 is undisputedly lawful on its face. Everyone agrees to that. It's a simple one-sentence policy, and it says employees can't be in the building on their off-duty hours, and they can't be in exterior working areas during their off-duty hours. What happened, however, is that on June 30th, 2022, on one location where the policy was displayed, an automatic templated boilerplate disclaimer appeared saying that Amazon reserved the right to depart from the policy if appropriate. Now, that wasn't supposed to appear there when the policy was written, so when the National Labor Relations Board Philadelphia office notified Amazon's counsel that it was there and that a union was challenging the disclaimer, Amazon promptly removed it. It was gone within 8 days of having appeared. And when it removed the disclaimer, Amazon sent an A to Z message. Now, A to Z is a software app that Amazon uses to communicate with its employees. Sent the A to Z message to every employee in the United States covered by the policy and said, oops, there was some language on the policy that wasn't supposed to be there. It's now gone. Here's a hyperlink to the policy without the disclaimer, and we assure you that we will not apply this policy in discriminatory fashion. Now, that assurance of non-discriminatory treatment also existed when the policy was first disseminated to employees on June 30th, 2022. I submit that the court's analysis here should begin with the statute that the board purports to be enforcing. The statute is also simple. It's just as simple and straightforward as the off-duty access policy and the disclaimer. And it says that employers can't interfere with employees' Section 7 rights. Section 7 rights being the right to organize a union and otherwise engage in group activity for mutual aid and protection in the workplace. The board never tries to explain, never does explain, how the mere appearance of this disclaimer somehow interferes with employees' rights under the Act. And I would ask you to imagine an employee sitting in their kitchen, opening the A to Z app, and receiving the notification that there's a new off-duty access policy, reading the sentence that says they can't be in the building when they're off-duty, which the board agrees doesn't violate their statutory rights, and then reads the next sentence that says, Amazon reserves the right not to enforce this policy if deemed appropriate. And how it can be that the employee reading the second sentence all of a sudden is chilled in their exercise of Section 7 rights. The only way to get there is the implicit assumption that underlies the board's decision that by reserving that right, it must mean that Amazon will, or at least could, enforce the policy discriminatorily. Could decide not to enforce it against somebody who's not engaged in Section 7 rights.
I have a question for you that I will also ask the board's counsel, which is whether deletion of this reservation affected Amazon's actual authority.
I don't believe so. I believe Amazon
It's
still...
a unilateral policy and can be changed unilaterally by its author, right?
This is true.
So I'm going to ask the same question of the board. How can not stating what is legally true and cannot be changed possibly matter to the National Labor Relations Act?
I don't think it does, Your Honor. I don't think that deleting the language changed the fact that Amazon could, in a strange circumstance that maybe we can't predict, decide not to enforce the
Oh, I
policy
can
or
tell
just
you
delete
one
it.
right here, and I'll ask this of the board too. There's a married couple working for Amazon. One gets a call from the other saying, I'm sick, please come and pick me up, right? The person who gets the call shows up, and Amazon lets him or her in. Amazon has a right to do that, whether or not there's a stated disclaimer.
Agreed.
I can't imagine a holding that allowing the spouse of the sick employee to pick up the other spouse violates the National Labor Relations Act. But that seems to be what the board has held, that any exceptions to a policy like this are illegal.
It seems to be to Amazon as well, Your Honor. Although at the same time, in briefing, the board says, well, no, there could be an exception because there's board case law that allows for certain exceptions. So the board speaks sort of both ways at the same time.
I've so far refrained from asking you what has to be the first question, which is, how can you make the current argument, given that apparently you did not attack Tri-County in the board's proceedings?
Because, Your Honor, we're not attacking Tri-County. The third prong of Tri-County, which is what is at issue.
You make Tri-County sound like a fork with prongs, or maybe like a deer
That's
with prongs in its antlers.
Your Honor, that is how it
You are
tends to be
attacking
referred to.
things said in Tri-County, whether they are statements or prongs or forks or tines or
Fingers.
yeah, who cares? You're attacking language in Tri-County on the ground that Tri-County differs from the National Labor Relations Act. Fine. The board says you did not make this argument adequately before the board.
We're not attacking Tri-County. There's the third part of the Tri-County test is a simple anti-discrimination test that you can't apply an off-duty access policy only to union activity. We have no problem with that particular rule. That's a fundamental rule under the Act. What we're concerned with is how the board in this case has misinterpreted or expanded or changed that test to be a no exceptions whatsoever under any circumstances rule, which is not found in Tri-County itself. It's found in this case. And we argued that that is not what the third tine of Tri-County means to the board. Now, the board decided to disagree with us, and that's why we're here today. But we did argue this to the board, and it disagreed. We're not asking the court to say that that
Your
third
reply
test is wrong.
brief says, quotes, one sentence of all the papers filed before the board. Is that it?
Quotes
Right.
one sentence.
Yeah, page 11 of your reply brief says, you told the board that interpreting the third prong of Tri-County to prohibit any and all ability to make exceptions would stretch the Act beyond its reasonable boundaries. That's it. I mean, that doesn't sound like a developed legal argument.
I think it was developed throughout all the briefing. I mean, that's it in a nutshell, and that's what I'm saying today, is that the way the board in this particular case applied that prong is divorced from the Act itself. And that's what we argued to the board below in all of our briefing. Now, in addition to our position that the disclaimer didn't violate the Act in the first place, Amazon would submit that it fixed any alleged violation by removing the disclaimer, telling everybody that the policy had been revised, sending them a link
If you
to it.
violate the Act for 8 days, you violated the Act for 8 days. And presumably, the board can insist that you announce that you won't violate the Act anymore.
Although the board
Why does it matter if you violated the Act only for 8 days?
the board does have
If you fire all the union organizers and then stop doing that after 8 days, you violated the Act.
Well, I understand, Your Honor, although I don't think this is quite the equivalent.
Of course
fact
it's
scenario.
not the same. But the proposition, we get, the common law dog gets 1 free bite. The NLRA employer gets 8 free days? That can't be right.
Well, Your Honor, under Pasavan and the board's own case law, they do agree that an employer can cure a violation if they do it effectively. And we would submit that it was done effectively here under these circumstances. This wasn't a case where an employer eliminated a policy and didn't tell anybody, or deleted 1 paragraph from a 60-page document, recirculated it, and didn't tell anybody what was changed. This was a pretty specific communication fixing the alleged error. If I could, I'd like to turn, unless the court has further questions on the disclaimer case, to the default judgment case, because I would like to address that as well. In the default case, the board concluded that Amazon breached a 2021 settlement agreement with the Chicago office of the National Labor Relations Board. The primary alleged breach was the existence of the disclaimer, which the board concluded was unlawful. I won't speak about that anymore. I've already covered that. What I'd like to talk about is why it doesn't matter anyway. It doesn't matter whether the disclaimer was unlawful or not for purposes of the settlement agreement. The settlement agreement had a specific promise from Amazon not to publish a certain type of off-duty access policy. The specific promise was not to publish one that barred employees from the exterior, non-working areas of the property. And there's a reason why that was the specific promise, because that was the issue in the settled cases. The 2020 policy implemented at the outset of COVID banned employees from being on premises, and the board took the position that that was too broad. The parties settled the issue, and Amazon promised not to issue a new off-duty access policy saying essentially the same thing. It didn't issue a policy saying the same thing, and no one argues otherwise. It also promised not to publish a lawful policy for 60 days after it started posting a notice to employees pursuant to the settlement. So there was a promise of forbearance. We won't even publish a lawful one for a period of time. Again, no argument that Amazon breached that promise. It waited beyond the forbearance period before publishing the 2022 policy. Instead, what the board seems to say is that by promising not to publish a lawful policy for a particular period of time, it also promised not to publish any sort of unlawful policy at any time ever. But that's just not what the contract between the parties says. The contract is not coextensive with the law. Of course, Amazon can't publish an off-duty access policy that's unlawful in any form, but that's what the first case is about. That's the remedy for that potential violation that the board had argued about, not an alleged breach of the settlement agreement. The second way the board determined that Amazon violated the settlement agreement is by not assuring employees that they would be that the off-duty access policy would not be enforced discriminatorily in the policy itself. So as I mentioned before, when Amazon published the policy on June 30th, and again when it republished it on July 8th, it sent a notification to every employee in America, giving them a link to the policy and promising in no uncertain terms that it would not enforce the policy in a discriminatory fashion. The board says that that assurance was supposed to be in the policy itself, not in the notification to employees. But again, that's not what the settlement agreement says. The settlement agreement says that the assurance of non-discrimination will be in said notification. Now, I understand that said notification would ordinarily suggest that somewhere previously the notification would have been described or mentioned, but it wasn't. What was mentioned previously was the reinstatement of a lawful rule. Amazon believed it agreed when it reinstated the lawful rule to provide a notification to employees of non-discrimination, and it did so. The General Counsel of the National Labor Relations Board bears the burden of proof on a breach of the settlement agreement, and also her agents were the drafters of that language. So that language should be construed to the extent it's ambiguous against the drafter.
On the ground that Amazon is some poor, helpless consumer that lacks lawyers.
Well, I won't say it lacked lawyers.
The idea of Amazon asserting contra profferentum against the Labor Board is absurd. You have better arguments.
Another argument we do have is that under the contract, Your Honor, Amazon negotiated for the right to notice an opportunity to cure any alleged breach, and it just didn't get that here. In the notice of alleged breach from the regional director of the Chicago office, it was asserted that Amazon did not provide an assurance of non-discrimination in, quote, its notification to employees. Amazon's counsel promptly sent copies of the two notifications to employees saying we won't discriminate in enforcement of this policy, and asked the regional director to please explain if there was something else Amazon was supposed to do. Her only response was, I believe Amazon has been provided with due process. And I respectfully submit that that is not sufficient notice of the alleged breach that was then litigated thereafter. The other alleged breach was the disclaimer's existence in June of 2022 through July 8th of 2022. That was not mentioned in the notice of breach at all. That was an issue being litigated by the Cincinnati office of the National Labor Relations Board. That case in Cincinnati wasn't mentioned. The disclaimer wasn't mentioned. The disclaimer had been gone for over a year, so there was no way for Amazon to realize that the disclaimer was later going to be alleged as a breach of the settlement agreement. Without legitimate, meaningful notice and an opportunity to cure, it's actually the National Labor Relations Board's general counsel that breached the agreement by issuing a complaint and requesting default judgment.
Is there some reason, by the way, why everybody is referring to this notice as a disclaimer? A disclaimer is something that disclaims authority or power to do something, whereas this tagline claimed a power to do something. It doesn't disclaim anything. So why are you calling it a disclaimer?
I shall henceforth refer to it as a reservation of rights, which I think is what it is.
That's what it is.
It's too late for me to go back and revise all
I
the
know.
briefs, Your Honor, but
Reading these documents, people calling things they aren't, is just makes them hard to get through.
Amazon respectfully submits that both petitions for review should be granted and both orders should be denied enforcement, and I will yield and reserve the rest of my time for potential rebuttal.
Certainly, counsel. Ms. Sheehy.
Good morning. Excuse me. Good morning, Your Honors. Barbara Sheehy for the National Labor Relations Board. I'm going to start directly with Judge Easterbrook's question. Since you previewed that you're going to ask me anyway, I'll start right there. So I'm going to start with actually what your second question was, which was, they're asking the employer counsel whether this issue about the standard, the Tri-County standard that was amplified in St. John's, whether that was an issue that was briefed, whether there was a challenge to that. And as we argue in our brief, and I think as Your Honor recognized, that was not a challenge that they launched. The exceptions brief, or I'm sorry, it was cross motions for summary judgment. It came up on sort of a different procedural than I'm used to, but it was in cross motions for summary judgment. In there before the board, the employer takes issue with the application of the third prong of Tri-County and as it was applied in St. John's. That is not a challenge to the standard. I know Your Honor has already articulated an issue or a concern with the standard, but Your Honor's concern notwithstanding, that was not raised by Amazon.
I must say, whether or not Amazon is properly attacking the prong of a pitchfork, Tri-County actually sounds like a pitchfork because they have 3 prongs. Anyway, whether or not we have a pitchfork in this case, Amazon has certainly argued before the board and is certainly arguing before us that telling workers about the existence of a legal right to change a policy cannot possibly violate Section 8 of the statute. When the legal right exists, whether the workers are told or not. Well, let me start unraveling that from the back.
Sure.
Do you agree that the legal right exists whether the workers are told or not?
I don't know that I agree that the unfettered right to deviate from the policy.
Amazon is the author of the policy and therefore can change it. Isn't that true?
That is certainly true,
It's
but
a
whether
unilateral policy, not a bilateral contract.
That's true.
That's all we need. So whether or not Amazon states on a web page or anyone else, we have the right to change this policy, they have the right to change the policy. Now, unraveling farther back, why does stating something that is true, whether or not it is stated, violate the National Labor Relations Act?
So this is a facial challenge. In a reasonable employee reading the policy, yes, there was the access policy, you can't come on the property outside your working hours. But the problem comes in is when you then tell employees that you have the right to deviate from this policy at any time. That is akin to going on property with supervisory approval. That's akin to going on property with managerial authorization. And under board law, that is not okay. That's
I'm
not saying
interested in board law. I'm interested in a direct answer to my question. Why does it violate the National Labor Relations Act? We have just been told in Loper Bright that we will determine what the law is. If there's play in the joints, if the law grants some discretion to the board, fine. But I don't see an argument that the board has discretion here. So why does telling the employees something that is true whether they're told or not, violate the National Labor Relations Act?
so I have a couple different ways that I want to answer this. The first one is the because board law in St. John's, they explain.
We're not dealing with board law. Forget board law. Why does it violate the National Labor Relations Act?
Could I say, as the board explained in a case, why issuing a policy that on its face tells employees you cannot come in on the property, period, that's a lawful policy, and then to say something along the lines of, unless we tell you it's okay, unless it's our event, that chills the exercise of Section 7 rights.
Amazon, you're not dealing with how we set this up.
I'm really trying. I'm not
Amazon
trying to.
has this right, whether it says so or not. Indeed, it can't get rid of this right. It is something that goes with being a landowner, right? It couldn't get rid of this right if it tried to. Even if it were to grant an easement to employees to come in, it would be a unilateral grant and could be unilaterally rescinded. So why does having this right violate the National Labor Relations Act? That's my problem.
So I'll go back to Tri-County then, what the board explained in Tri-County, where they say you can have, I'm sorry, I can't see beyond what the board has though. So I'm trying to remind the court, I'm going to get to the explanation in Tri-County, but what I want to say also, this conversation that you and I are having is exactly why the obligation is on the employer to make these arguments to the board, so the board can do a better job of articulating what the concerns are and responding to those. I am limited now to what the board has already said, which is Tri-County. In Tri-County, they talk about whether if an employer has absolutely a property right, and if it wants to exclude employees, absolutely, you can jealously guard that right. And if you can say nobody will be allowed on the property outside of those that are working, that is jealously guarding the property right, and the statutory right, Section 7, Section 1, Section 7 rights will yield to that employer's property right. However, as soon as you start making exceptions as an employer to the universal ban.
Oh no, that's a different problem. As soon as you start making exceptions, the actual exceptions may violate Section 8. I grant that. Amazon is not alleged to have made any exceptions. What we are dealing with in this case is whether it violates the Act to announce that you have a legal right to make exceptions, even though you don't make any exceptions, and even though there's no allegation of anti-union discrimination.
And so what that announcement, what the board looks at, is that announcement has the effect of chilling the exercise of speech on the property, where, again, the Beth Israel, the Supreme Court talks about.
So the premise is that the workers are too stupid to know that Amazon has that right, whether it announces it or not.
I would not say that, no, Your Honor. I would not say that.
It's what you did just say.
I did not say that,
The
Your
only
Honor.
reason they are being chilled is because they're being told something that they otherwise don't know,
Or they're being
even
told.
though it's absolutely true.
Or they're being told by this massive employer that you can come onto the you cannot come onto the property, or you can only as we deem appropriate. So I don't think that I am saying, and I know I'm not saying that it's a dumb employee that's reading that policy. I'm saying an employee that reads that policy would reasonably understand Amazon is going to control when I get to come on and off this property. So if you remove that reservation of rights,
And the union knows that whether it's stated or not.
there's not a union here. These are employees. There's not a union at this. I'm not sure about any facility. I know at the facility where this happened, there is not a union.
Somebody tries to organize them, that will be a union.
So they've been trying, Your Honor. They've been trying.
I understand that. And presumably, the board is trying to protect the rights of employees to organize.
Or enforcing the statute, right?
But I hope you can see what my problem is.
Your Honor,
The board has treated every sentence in Tri-County as if it were identical to Section 8 of the National Labor Relations Act. And that can't possibly be right. The statute is what it is. The board can interpret the statute. We can interpret the statute. But all the board seems to have done is interpret its own decision and forgot about the statute. And it's a problem.
Well, it wouldn't have been a problem if, and I'm not necessarily agreeing with that presentation of what the board did here, but if that's truly how Amazon saw that that's what happened, it was incumbent on Amazon to tell the board that. Tell the board, we don't think Tri-County makes sense anymore.
Now,
We don't think.
Okay, well, I had a little conversation with Mr. Stolzenbach about that. Amazon's reply brief quotes some language that says, well, look, if you interpret the third prong of Tri-County to do that, you're extending the act beyond its reasonable boundaries. Now, of course, that's in a reply brief, so you didn't have a chance to reply. I asked Mr. Stolzenbach, is that it? One sentence? And he said, no, there are lots of things like that. Now, are you saying there aren't lots of things like that, that sentence is all by itself?
I'm saying that in the motion for summary judgment, it is not clearly presented by the employer that they were challenging, that they were challenging more than just the application of the third prong. And I'll tell you why, because I think it's quite clear why they weren't doing that. Loper-Bright hadn't issued yet, is when they had filed their motion for summary judgment. As soon as Loper-Bright issued, then all of a sudden a light bulb goes off and says, wait a minute, we can go after the board for the very exercise of its interpretation of the statute, even though we never did it before. We just have to convince the court that we are in statutory interpretation grounds. And the board's response to that, were I entitled to a cert reply, for instance, our response to that would be, that is not a sufficiently preserved argument. That is a genuflection to Loper-Bright and a last-ditch effort to bring that case into this one, and it's not. This is undisputed facts.
Do you think that what we need to do is figure out whether Mr. Stolzenbach is right, that this sentence, the one that's quoted at page 11 of the reply brief, is just one of many, or is all by itself? I mean, I hate to think that the Court of Appeals is forced to do a census of how many sentences like that are there.
No, I don't think that it requires that at all. There is not in the summary judgment papers, in the briefs to the court, in the briefs to the board, there is not the argument that this standard is wrong. We had a right, we have this, exactly as Your Honor has articulated. That is not an argument that Amazon has made. I'm not saying that in a later case, if somebody pulls the transcript from this case and says, look at everything that Judge Easterbrook said, these are now in our exceptions. Board, what do you have to say about this? Then certainly we'd be having a different conversation. But that is not at all. So, and I don't think it requires any sort of special reading or census by this court to look at the summary judgment papers and understand that the set of arguments and the set of concerns that Your Honor is laying out is not what Amazon did.
I want to make sure I'm understanding your answers here. You're saying that when Loper-Bright came down, it put ideas, that everyone's reading it, Amazon reads it, they try to make the arguments potentially. You're not conceding that Loper-Bright applies here.
Absolutely not. And so, no, we say in our, as we say in our brief, we say Loper-Bright doesn't, first of all, 10E. Obviously, we have our jurisdictional bar argument, which I'm not going to flog that horse anymore.
It has nothing to do with jurisdiction. The Supreme Court held that exhaustion requirements are non-jurisdictional.
No, but to challenge the very test, I think we would be arguing, to raise Loper-Bright, I think we are saying that is jurisdictionally barred.
That's what your brief says. But that is flatly inconsistent with the Supreme Court's holding in Santos Zakaria against Garland, which you don't cite or discuss.
We do not, no.
The Supreme Court has held that exhaustion requirements in federal statutes are uniformly non-jurisdictional. Anyway, back to Judge Kollar's question.
So as we say, again, moving off the jurisdictional issue then, as we say in our brief, we do not believe that Loper, first of all, we don't believe it applies. There's not a statutory interpretation. It wasn't presented as a statutory interpretation. I'm sorry, I'm going to clarify. That's my jurisdictional claim, that they haven't launched a statutory argument to bring us within Loper-Bright. Not that Loper-Bright doesn't apply. Sorry, just to be very clear.
There's no jurisdictional problem in this case. Okay. None.
Okay.
Just believe me.
Okay.
We have held that. The Supreme Court has held that. Administrative exhaustion requirements are unrelated to jurisdiction. Just proceed.
So, but as we say in our brief, and we would request further briefing on this if this is an actual concern for the court. We maintain, and we've maintained in other litigation, that the board had special expertise discretion recognized long before Chevron and recognized long after Chevron, and that continues. So certainly if this court is concerned that whether Loper-Bright has some sort of application, we would request supplemental briefing on the issue of post-Chevron discretion still given to the board.
Loper Bright is raised in Amazon's brief. You had every opportunity to reply in your brief.
No, but we're saying that we are maintaining that Loper. Well, we do put in our brief. Then we do put in our brief that post Chevron discretion still remains with the board, and that transcends Loper. So I still would request supplemental briefing on that specific issue. That notwithstanding, I think there's enough in our brief to go with that the board still maintains discretion, and that this is a standard case decided day in and day out by the board. It's not a complicated set of facts. It is settled facts and the application of those facts to settled law. This is not an interpretation of the statute. And again, for that reason, we're saying Loper Bright does not apply.
Can I just also ask, as Judge Easterbrook said, if there's a violation, there's a violation, and we need to address it. That's what we do in this branch. But Amazon puts a policy out. If I'm reading the record right, and OMB says, "Wait a second, that policy is violates Tri-County and the settlement agreement." It's changed 8 days later.
Sure.
I'm going to decide the case that's in front of us, but do you have anything you want to share about that decision?
Sure. So there were still 200 employees that saw it, and yes, it was changed. There's no dispute about that. But let's be clear on what the distinction is between rescission, which they've rescinded, versus repudiation, such that they are not liable anymore for anything, any prosecution or anything under the Act. That requires something more than just rescission. They rescinded. They didn't repudiate. The law is very clear on how they have to repudiate. And I think
you had your discretion, you exercised it, and
it's not. They did not. And so I guess the main issue, and this is clear in the board decision, I think the main issue is, yes, you rescinded, but you didn't tell anybody what you rescinded. Nobody, unless you did a screen cap of what the first policy looked like and the second policy, you had no idea what was changed. And on top of that, they tell you when you made the change, there's no substantive change at all in the policy.
What were they supposed to say? I could imagine sending out, our first policy contains a reservation of right to change the policy. We are hereby notifying you that we have a right to change the policy, but we are notifying you that we are no longer notifying you that we have a right to change the policy. They can't say that reservation of rights is not true, because it is true. So what is it they were supposed to say?
I think, Your Honor, premised in the question is sort of the disagreement we've had before as to whether the policy with the additional language is unlawful on its face. So I'm going to answer it slightly differently than to say that what they could have done, they don't have to acknowledge, you don't have to do a mea culpa. You can look at other cases. For instance, ExxonMobil, the employer there said, we issued something that could be construed as this. So here they could have said, we issued a policy that could be construed as coercing the exercise of your rights. It's hereby changed.
They don't have to fall on their sword legally.
There is an admission of wrongdoing or some specificity.
They don't have to concede.
That's not conceding anything. To say we did something that could be construed as, that is not a concession.
Okay, all right. Let me ask you one more question about related to the 8 days. This is on the settlement agreement part. The settlement agreement seems to have in it a requirement that the board give notice to Amazon and an opportunity to cure.
Yes.
How did the board comply with that obligation?
It specifically applied on August 14th with the issuance of the notification to Amazon, identifying the breach. And then, as we point out in the brief, there were, and then I'll go further. So there was the specific notification of the breach on August 14th. There was Amazon's reply that we can look at. I mean, that's not the board doing it, but
what is the opportunity to cure?
They could have repudiated, fully repudiated.
No, they can't repudiate it because they have a legal right to change the policy, whether they've notified the workers or not.
Your Honor, we're going back to the fundamental difference that we have, that this that with the words in this policy makes it facially unlawful.
Look,
frankly, your question is just saying over to me that you find it lawful.
The contract, settlement contract is a contract.
Sure.
The contract obliges the board to give Amazon an opportunity to cure. How did the board keep its contractual promise? What opportunity did it extend to Amazon?
So there were 6 paragraphs total. The first 5 are cease and desists. They say, give us evidence that you cease and desisted. I assume that happened, because those aren't part of this case. The 6th paragraph says, show that you have lawfully implemented a policy more than 60 days out, not in question, and that you issued said notification, or that said notification of the assurance of rights was in the policy. So the board notifies them that they find them in breach. And let's not forget, contemporaneous with all this is the severance of the very access policy from the complaint, the severance of that allegation from the complaint. Happens on June 27, 2023, sorry. So about 45 days before Amazon is notified of the breach, they are clearly notified that there is an issue with the access policy of June 2022. Then, so there's the allegation is severed, new complaint issues, and then on August 7th, there is a motion for summary judgment filed by the board that lays out the entire legal case. Again, before the notice of breach goes to Amazon. The entire legal case for that case is laid out. And on top of that, you have conversations that are happening. The record doesn't disclose exactly what those were, but in the breach letter that goes out on August 14th, and Amazon takes no issue with this in its factual recitation of the case, there is reference by the regional director in that letter saying, as we've said in several conversations, and then referring to the access ban to that breach. So and then there are conversations, and then there's the August 14 notice. There's the August 28 response that provides the only documents that were relevant in the case. There's only one access policy. There is not a question.
Just don't understand what any of this has to do with cure. But your time has expired. Thank you, counsel. Anything further, Mr. Stolzenbach?
Yes, Your Honor. At the record on appeal in the disclaimer case from pages 251 to 56 of the record, there's an entire argument.
We're back to disclaimers.
There's an argument about the reservation of rights. That the heading is that the disclaimer did not cause the policy to violate the act. Fundamentally, this whole case is about whether the reservation of rights violated the act. That is sufficient to raise the argument that we're raising now. But throughout those pages, which I'm not going to read to you, of course, there's more than one reference to the fact that the interpretation of Tri-County that ultimately the board latched onto here would be beyond the realm of what the act actually says. Amazon preserved its argument throughout the brief to the board.
But counsel, did you preserve an argument that Tri-County was wrong?
Again, Your Honor, we're not saying that Tri-County itself was wrong. The third part of the test that says you can't discriminate is accurate. In the notice of potential breach, or the assertion of breach, counsel said that Amazon could have repudiated the disclaimer in order to cure. But again, there's nothing in the letter that says the disclaimer's at issue and we need you to do more and we need you to repudiate anything. And as far as the notion that somehow the timing of the issuance of the complaint in Region 9 could have told Amazon and its counsel that the only issue that was going to be litigated as a potential breach was the disclaimer, that's not consistent with the record and it's not consistent with the facts. As the notice of alleged breach begins, it cites 2 cases in Region 13 out of the Chicago office related to the off-duty policy, making different arguments having nothing to do with the disclaimer. The counsel for the National Labor Relations Board linked to the docket of that case, which is still ongoing and is pending before an administrative law judge today. The mere mention of an off-duty policy and there being issues would not have caused Amazon to know that the disclaimer, the reservation of rights, that had been deleted over a year ago at the Labor Board's request was still an issue. If the court has no further questions, I have nothing further in my argument.
Thank you, counsel.
Thank you.
The case is taken under advisement. If we require supplemental briefing, we will let people know. Case number 4 is Moratz against Reliance Standard Life Insurance. Mr. Saint.
Thank you. If it pleases the court, I'm Robert Saint for the plaintiff appellant, Karen Moratz. The central issue in this appeal is whether Karen Moratz, as the plaintiff in an ERISA disability policy, had the right to challenge the initial adverse claims determination made by Reliance when they found that she was not eligible. When I say not eligible, I mean not insured.
Has Moratz filed another claim for benefits?
She is not.
Now, what Reliance said was roughly, if you want to change the onset date of your disability, go back to square one and file another claim. Why does that violate either the policy or ERISA?
It violates ERISA, and I think the district court, Your Honor, got it wrong when it interpreted
So
ERISA.
what section of ERISA? Point me the section and tell me why.
Okay, so what the court relied upon was...
I'm not asking about the court.
Okay.
I'm asking you to tell me which section of ERISA this policy violates and why.
Subsection H, which governs...
No, you have to start with a section number before you start with a subsection.
It violates 29 CFR section...
No, that's not part of ERISA. That's a regulation.
Right.
So, are you claiming that this policy violates ERISA?
It does. No, the
What
policy does
look,
not.
look. I'm asking a simple question.
Yeah.
What section of the statute does it violate? Then we can move to sections of regulations.
Okay.
Does it violate a section of ERISA?
It does. I do not have the statute in front of me. I do have the regulation.
All right. I did not see an argument in your brief. That's why I'm asking. All right.
Yes.
So you say it violates a regulation. Let's go to the regulation.
Okay.
Okay.
It violates subsection H of the regulation.
No, their regulations also begin with numbers before
Okay,
you get to
29 CFR 2560.503-1.
Yeah, well, that's about 100,000 before we get to H.
Yes.
Okay, so,
But it is subsection H of that specific regulation site. And subsection H governs the right of a claimant to seek an administrative appeal of an adverse claims decision.
yeah, look, this regulation does not address the question I am asking, which is, why can't an administrator or other fiduciary say, if you want to change your onset date, you do that at the beginning of the process or by filing a new claim, rather than doing it on appeal? The rationale for this is perfectly straightforward. If you claim an onset date, all the evidence will address that onset date. On appeal, you now have a mismatch between the newly claimed onset date and all the evidence. So you got to go back and start over in some way. You can either remand it and start over or file a new claim and start over. Why does either of these things violate the statute or a regulation?
Because she was, Karen
No,
Moratz.
it's not what this plaintiff was or wants. I'm asking you a legal question about the meaning of statutes and regulations. What is it that violates a statute or regulation about that policy?
Because she was permitted to address that decision on
Look, what
review
what
and
your
administrative
client
appeal.
was permitted to do does not answer my question, which has to do with the meaning of legal texts. And I would really appreciate it if you would focus on the legal texts.
When she filed her claim, it was denied. The law permits her to file an administrative appeal. That's what she did. The onset date of her actual injury, illness, was in late 2020, early 2021, which we agree she was not employed by ISO at that particular time. It was not until September 1, 2021, but she did not file her claim until after she was reemployed, when she filed her claim in February of 2022. That would have been the right time for her to file the claim based upon the language in the policy. And when the adverse decision, initial decision, was denied, she had an absolute right to submit an administrative appeal to correct the factual basis for the denial. And it was the Reliance's failure to recognize that.
You realize you're just not addressing my question. You're not even mentioning any statute or regulation here. You don't seem to realize that the black lung benefits system, the Social Security disability system, almost every disability system that I'm aware of requires exactly what Reliance required. That if you want to change the alleged onset date, you go back and start over. Is there any disability system that allows the onset date to be changed on appeal after the evidence has been submitted? Any at all?
Your Honor, I'm unaware of a specific statute or regulation that says you can't correct the initial application within the administrative
That's
appeal.
not the question. The question is whether there is a statute or regulation that forbids an ERISA fiduciary from having that policy. Not whether the statute itself requires the policy, but whether it forbids that policy. That's what I've been asking you all along.
What I'm aware of is that ERISA requires Reliance and any other plan administrator to set forth the rights of the party, the rights of the claimant, and one of the rights that they set forth based upon ERISA is the fact that she had a right to appeal any basis of the initial denial of her initial application. And she did that. And it is our contention that she corrected the factual flaw in the initial application, and she was eligible at the time that she filed her claim, and there would be no reason to go back and refile the claim when she filed it on a timely basis. I see that there's a minute 20 left. I'd like to reserve some time.
Certainly, Counsel.
Thank you.
May it please the court. Good morning. I'm Joshua Backrack.
Mr. Backrack.
Thank you, Your Honor. I represent the appellee here, Reliance Standard, and I'd like to address the questions of the court, Judge Easterbrook here. There is no violation of ERISA. In fact, what they tried to do here is the violation of ERISA, because ERISA Section 29 U.S.C. 1133 states that if there's a denied claim, there must be a full and fair review. The regulation that counsel referred to, 29 CFR 2560.503-1, also lays out how an ERISA claim has to be followed. And that is, there's a claim submission, there's a decision. If there's a denial, then there's a right to appeal. And if that appeal is submitted, then that has to be decided. So there are actually two decisions to be made under the statute and under the regulation on any claim. But here, by submitting, and it is a new claim, counsel says it's a correction. It's not a correction, it's a new claim. If there is a new claim, that only allows my client one opportunity. It doesn't allow them to correct any potential mistakes that have made. And so counsel says that the regulations here permitted her to address the decision that was made. The decision that was made was that she was no longer covered under the plan in December of 2020 when she claims that she was disabled. It is during the appeal she submitted a new claim. She claims that 9 months later, in September of 2021, she started working again and that she became disabled 2 weeks later. So that doesn't involve whether there was a termination of benefits. Those involve the questions of, did her coverage renew under the plan? Was she actively at work as that phrase or that term is defined in the policy? And if she was, the effectiveness or the applicability of the pre-existing conditions exclusion. None of that had to be addressed based on what she actually submitted, a claim on December 20 of disability as of December 2020. There's also the fact, and this was raised to your honor as well, when you're asking about whether there are violations of the statute and then the regulations that come into play. The statute defines a claim for benefits as a request for benefits that is consistent with the procedure set forth in the plan documents, right? The plan documents here state that you must submit a form with your claim. And there was a form submitted with the claim here, and it stated there was a disability as of December of 2020. That is the only claim that was ever submitted. So this is a new claim as of September of 2021. And I just want to correct one other point that was made by counsel. And counsel stated that his client had to wait until after September 2021 to submit her claim. The fact is that she did. In January of 2022 is when she filled out those forms in which she said that she became disabled in December of 2020. And more importantly, she claimed that she had not returned to work. So she's now claiming that she returned to work in September of 2021, but 4 months later, she admits that she'd never returned to work. There are inherent inconsistencies here. And that is why a new claim needed to be submitted, and it just simply wasn't done here. It's inconsistent with the statute, the regulations, and just common sense tells you this is an entirely new claim. So unless there are any questions from the panel, we would just ask that the decision of the district court.
Is there a period of limitations in the contract?
Is there contractual limitations?
Can Morat still submit a new claim?
She could submit a claim. Is it valid? I don't believe it would be.
Well, that's a substantive question. I was just asking about time. She still has time to submit a new claim.
I do not believe so, Your Honor.
All right.
My understanding is that it is 3 years from the time proof of loss. Well, actually, I take that back. It is 3 years from the time proof of loss is required, I believe. And I didn't look at the exact language. So if that's the case, there's usually 1 year to submit the proof, plus you add the 3, that would be 4 years.
It might be 4, so she might still have time.
She might still have time.
Okay. Well, we will leave that to Morat and Mr. Saint. Okay, thank you.
Your Honor.
Mr. Saint, anything further?
Just briefly. And I understand Your Honor's questions. And I know I didn't artfully answer those questions, but one thing that the policy in compliance with ERISA gives Karen Moratz the opportunity, and that is to file an appeal from any denial. And that's the language in the policy of any denial or a part of it.
Look, counsel, I think you're still not seeing the problem. You have a statutory right to appeal from the district court's decision to the Court of Appeals, but that doesn't mean we will build a new record on appeal. You are stuck with the record made in the district court when you appeal. And that's essentially what Reliance said. The record made in the claim was for a disability that began sometime in the summer of 2000. And Reliance said, you're stuck with that on appeal. If you want a different record, file a new claim. It's the very thing we would say if you tried to argue a different claim on appeal.
Your Honor, my interpretation has always been when a claim is denied, there's an adverse decision that any claimant, as a part of the process, has the right to submit an administrative appeal.
Yes, you're
and
still
correct
not
the
getting
record.
it.
So
The fact that you can appeal from the district court to the Court of Appeals doesn't mean you get to change the allegations of the complaint. Okay, the case is taken under advisement. Our next case is Green against the Milwaukee County Circuit Court.
Good morning, Your
Mr.
Honors.
Wasilewski.
John Wasilewski, appearing on behalf of Mitchell Green. This is a criminal case where a mistrial was declared in the course of the trial, and the question before this court is whether that mistrial was manifestly necessary. That is the 200-year-old standard that's easy to state, but leaves a lot of room.
That, of course, is your argument, but the state argues there are a whole bunch of procedural issues that you might want to address.
Very well, Your Honor.
The state says that 2241 can't be used in the way it's being used here. As I say, you might want to address that. You might want to address Younger. That's one thing you might want to address.
Younger, in my reply brief, I attempted to address Younger. I did a wide survey and found that 8 circuits have recognized that double jeopardy presents an exception to Younger.
That can't possibly be right. If you file a 1983 suit while a case is pending, there's no exception to Younger. Now, you might be saying that these circuits have thought that 2241 is a potential exception because Younger construes Section 1983. Is that what you're saying? Look, let me put it a different way. A court of appeals cannot make exceptions to a holding of the Supreme Court. Only the Supreme Court can make exceptions to its own holdings. So we need to establish what is the holding of Younger. How would you phrase that holding?
Younger is an equitable case that holds that federal courts should not interfere with state court ongoing proceedings.
No, that's not what Younger holds. You're now restating the Anti-Injunction Act, which is 2283. The Anti-Injunction Act has some exceptions. One question is whether 1983 is such an exception. The Supreme Court held yes. And then it held that there's an equitable exception to the exception in the Anti-Injunction Act. Younger has nothing to do with 2241, counsel. All right, maybe we should proceed.
Counsel, I do have one other Younger question. Was Younger addressed below? Did the state raise
No.
Younger?
I filed the habeas petition, and the answer did not mention Younger or abstention. State's brief did not mention it. The The magistrate, understandably, didn't mention it because no party mentioned it, and it is being raised for the first time in this court in the state's response brief.
All right, let me ask a different foundational question. At least I tend to think it's a foundational question. The manifest necessity for a mistrial may exist if the defense introduces important evidence in violation of a state law or judicial ruling. There are two kinds of arguments that might have been made for what the problem was in this case. One is that there is a state statute, rule, or decision of the state Supreme Court requiring all Denny evidence requiring the defense to notify the prosecution before trial about all Denny evidence. The second is that there was a dispute about whether this particular testimony was Denny evidence. Which of these is at issue here, or maybe both?
I would say both, Your Honor. Denny is Wisconsin's third-party defense case, and it basically is a defense that you say, my client didn't do this, commit this crime, somebody else committed this crime. Mr. Cousins' testimony doesn't put himself in the position, it puts himself in my client's shoes as the driver of the car that transported the woman for prostitution purposes, but his testimony is he had no idea what was going on. At least so far as the driver is concerned, if you accept Jonathan Cousins' testimony, then there's no crime with respect to the driver because he was doing this just for gas money without being concerned about the purpose of transporting these people. So that's one problem.
It may not be evident to you why I asked the question. The first question, whether there's a requirement to give notice about Denny evidence, sounds like a question of federal law, that it's not manifestly necessary if the state law didn't have such a requirement at all. The second question sounds like an issue of state law only. And it's very well established that a federal court does not issue a writ of habeas corpus when a state judge misunderstands state law. And it seemed to me important to tease out what is the real federal rule from what is a potential misunderstanding of a state rule. Well, I would appreciate it if you'd address that because it's potentially dispositive.
Well, I was speaking in the abstract about whether Denny applies or not. I agree it's a state issue, and I think I didn't really argue in my brief that Jonathan Cousins' testimony isn't Denny evidence. What I did argue is there's no statute, rule, or case that says you have to notify the other side of your intent to present Denny evidence. There are such rules in Wisconsin law for other things, such as alibi. There's a statute that's self-executing. If I wanted to present an alibi on behalf of a criminal defense client, I have to give notice.
Yeah, I hope you're now getting to why I have asked this question, because whether there's a requirement to notify about Denny evidence is potentially of federal significance. Whether the state court misapplied Denny seems to be a question of state law, and you really need to be on the first and not the second.
My focus was simply on whether there was an error committed in presenting Jonathan Cousins' testimony.
An error of state law does not support a federal writ of habeas corpus. It's not clear that you're seeing the distinction I'm trying to draw.
Well, in the Arizona versus Washington case, that was all about a defense counsel who promised what was basically inadmissible evidence that was very damaging to the state, and the Supreme Court reviewed that and reviewed what the defense tried to put in to say that this was admissible evidence, and since the defense didn't present much of anything from my reading of that case, they went ahead with the presumption that there was an error. It was an error of state law, perhaps, but there was an error that potentially affected the impartiality of the jury. And it was only after that finding and proceeding from that that they went on to address whether the court exercised sound discretion in declaring a mistrial. And that is what I think is missing here. There is no error of state law or otherwise that was done by presenting this testimony without notice. There's reference in the magistrate decisions below to proper notice, but that begs the question, what notice is proper? And there's nothing cited, no rule, no case that says before trial, defense counsel shall give notice of intent to present any evidence. It's often dealt with in motions in limine, where prosecutors want any evidence and a list of other types of evidence to be not presented without prior notice, but there was no such motion in limine filed in this case, and the motions in limine that were filed were never addressed and turned into orders in limine. So this case differs from Arizona versus Washington because simply in analyzing whether there's manifest necessity, there's no error for the mistrial to correct. I understand that the trial judge was not happy that this evidence came out without prior notice. The judge thought there should have been. It goes against his way of doing things, his preferences. But throughout this litigation, and it's been through a number of steps, there's never been a citation to anything that says that defense counsel for Mr. Green committed an error by presenting this testimony the way he did. So it begs the question, if mistrial is a remedy, a drastic remedy, what error was it designed to cure? And that question, it begs an answer, and I don't think the record presents one. The evidence was found admissible for purposes of any future trial, which shows that the nature of the testimony of Jonathan Cousin didn't affect juror impartiality. The judge even said, well, the jury's either thinking clearly Mr. Green is innocent based on Jonathan Cousin's testimony, or Jonathan Cousin is just covering for him. That's kind of saying what you could say about any evidence. Maybe the jury will believe it and maybe they won't, but it's not an error. So I don't think the court followed the steps that are set forth in Arizona versus Washington, and I don't think the court really exercised sound discretion otherwise. For example, Arizona versus Washington says that one of the considerations the court should make is the double jeopardy impact or effect in the event a mistrial is declared, and double jeopardy is simply not mentioned. Manifest necessity wasn't specifically mentioned, although Arizona v. Washington says it's a matter of substance and not form. So I'm asking this court to find that this mistrial is not supported by manifest necessity and that Mr. Green should not be tried again.
What standard of review would you suggest we use? I'm looking at the trial court judge's decision, okay? And for the decision on manifest necessity, not whether this happened to be Denny evidence or not.
Right.
What standard of review should I be using?
Arizona versus Washington sets forth basically a scale where on one hand, the classic instance of the mistrial declared on a hung jury is entitled to great deference. The judge's decision that an error may have affected the impartiality of the jury is also to be granted great discretion. But what really happened here is, frankly, the prosecution got caught unaware and unprepared, because even though Jonathan Cousin was on a witness list 5 months before trial, the state took no steps to ask for discovery, and they weren't prepared to meet the defense.
I did not understand my colleague to be asking you to recite more of the facts of this case, but to answer a legal question, let me ask you a variation of it. What do you think is the difference between the standard of review articulated in Arizona against Washington and the standard in Section 2254D, the statute you were trying to avoid?
2254D applies only to reviews of state court judgments. There is no state court judgment here, and therefore I'm not sure if I'm misunderstanding your question.
About the difference in the substantive standards, right? The judge who decided this case in the district court said one reason not to use 2241 is because it seems to allow review more readily than 2254D, and Congress is trying to crack down on federal judges taking what amount to de novo review of state decisions. So I just asked you, how do you see the difference, if any, between the standard in Arizona against Washington and the standard in 2254D? I don't know how you could read the district court's decision and not be prepared on that question.
I agree with the district court's decision that 2241 simply requires the court to determine whether or not the defendant is in custody in violation of the Constitution, and that it doesn't have the greater scrutiny aspects of 2254. I will, if the court has no further questions, reserve the remainder of my time for rebuttal.
Mm-hmm. Certainly, counsel.
Thank you.
Mr. Blimling.
Good morning, Your Honor. May it please the court. Assistant Attorney General John Blimling.
Let's start with Judge Kollar's question. Was Younger ever raised in the district court?
No, Your Honor, it was not.
All right. Second question. What relevance could Younger have when all state remedies have been exhausted? The holding of Younger is that you have to go to state court and present your federal arguments to the state criminal court before coming to federal court. And as far as I can see, Green did exactly that, exhausting his state remedies through the Supreme Court of Wisconsin. What state remedy does Green have at the moment that has not been exhausted?
None, Your Honor.
So Younger, by its own terms, drops out. Right?
I disagree, Your Honor. And
you disagree why?
I think
Younger said you must exhaust your remedies in state court before coming to federal court. And you just agreed with me that Green did that. What else does Younger require?
I think Younger reflects, and this is at the beginning, kind of in the introduction of Younger. Younger talks about the national policy forbidding federal courts to stay or enjoin pending state court proceedings except under special circumstances. And I don't read that requirement as only requiring exhaustion of state court remedies. And so
do you think that the Younger against Harris decision repeals Section 2241 for state prisoners?
No.
What scope does it have on your understanding of Younger?
What scope does 2241 have? on
Give
that?
me an example of the proper use of section 2241
Sure.
for a state prisoner on your understanding of Younger.
So I have limited my argument related to
I'm
Younger.
not
to-
asking for you limiting your argument. I said, give me an example of the proper use of 2241 on your understanding of Younger.
2241 would be an appropriate avenue for a defendant to seek relief if the defendant had exhausted his remedies without ever receiving a decision on the merits of the double jeopardy claim.
Then you haven't exhausted your remedies.
So what could happen, and what happened here, we could tweak the facts to sort of tease this out a little bit, Your Honor. What happened here is Mr. Green filed a motion to dismiss in advance of his retrial on double jeopardy grounds. The trial court denied that motion to dismiss, and Mr. Green moved for interlocutory review of that decision.
And got it.
And he got it. If, however, so that right isn't guaranteed by statute in Wisconsin. It is strongly recommended by case law in Wisconsin, encouraged, and it should be, because Abney and related cases do raise the point that the double jeopardy right is important in advance of retrial. But if Mr. Green had petitioned for leave to appeal that decision and had not received decisions on the merits of his double jeopardy claim, then I think where that leaves him is in a position where he has exhausted his state remedies because he's asked the state appellate courts to look at this and they have refused to do so. But he has also not received a decision on the merits of that double jeopardy claim, which I believe he is entitled to under Abney and the related case law.
I'm just lost. I mean, suppose a defendant in state court goes to state court and says, your prosecution of me violates the First Amendment, and I want it dismissed. And the state judge says, I just don't enforce the First Amendment in my court. Go away. You think federal court is still closed under Younger?
I think in that situation, if he has sought interlocutory review,
He's done what he can in state court, and the state court has basically put its fingers in its ears. Then there's no problem under Younger. I'm asking you to tell me what's left of 2241, because in that circumstance, you can come and get an injunction despite Younger.
So I think the difference in that example is whether the state courts have issued the decisions on the merits, because I think ultimately when you look at the exceptions to Younger, it comes down to the likelihood of irreparable harm. And so that calculus is different on when the state appellate courts have heard the claim, decided the claim on the merits, than when they haven't. And so fundamentally, and I think it's sort of an interesting point in this case, which is, what do we do with the Wisconsin Supreme Court decision here? I mean, if we proceed under 2241 doesn't mention state court decisions at all. It doesn't really contemplate that. There's no standard of review articulated beyond that in 2243, which is as law and justice require. And so it puts this court and the federal courts generally in this sort of awkward position of, how do you respect comity and federalism when there is a state Supreme Court decision
How about
here?
by following Arizona against Washington? How would you articulate the difference, if any, between the standard of review in Arizona against Washington and the standard of review in Section 2254D?
So the standard of review in 2254D under the Anti-Terrorism and Effective Death Penalty Act looks for, contrary to or an unreasonable application of federal law as stated by the Supreme Court of the United States. Under 2241, we look at, I can see that maybe I'm not answering your question, Judge.
I was trying to be precise, asking you to compare the standard of review announced in Arizona against Washington with the 2254D standard.
Sure.
How is Arizona against Washington, in your worry, more favorable to defendants?
Arizona, I think with the 2254 standard, sometimes in those 2254 cases, we refer to double deference. Essentially, there is a layer of deference that comes from the standard under 2254, and then the standard of applying that specifically. So the Wisconsin Supreme Court here.
I really, really would appreciate it if you would discuss the Supreme Court's decision in Arizona against Washington.
Sure.
You seem to want to discuss almost anything else.
Arizona against Washington asks whether the trial court, in declaring the mistrial, exercised sound discretion. It's looking for the manifest necessity for that mistrial to be declared, and it is a deferential standard to the trial court's decision.
Is it more deferential or less deferential, do you think, than 2254D?
I honestly, Judge, I haven't.
It could well be more deferential than 2254D.
It may be, but
So why are you running away from the more deferential standard? Is the next question.
I'm not running. At least I'm not intending to run away from it, Judge. I guess my point would be that under a different standard of review, it would review the state court's decision both under the more deferential standard of review and under the Arizona versus Washington standard of review, that double deference that I discussed earlier that we sometimes do see in habeas corpus cases. So I'll turn to the exercise of discretion here and a few points that I want to raise about.
I want to ask a strictly legal question before we get there, which is where do I look in Wisconsin law to find a requirement that a Denny defense be that the defense give notice of a Denny defense before trial starts?
I think it is, practically speaking, built into the Denny decision itself. There was
No. The Denny decision is substantive. Is there a statute requiring notice?
No.
Like the alibi statute?
No.
Is there a rule requiring notice?
Not specifically.
Anything like Federal Rule 16 or notice of an insanity defense? Is there a holding of the Supreme Court of Wisconsin requiring notice? Well, the Supreme Court of Wisconsin's holding in this case might satisfy that, but obviously that decision postdates the trial.
Right.
So where is it?
So 2015 State versus General Grant Wilson is perhaps as close as the Wisconsin Supreme Court gets to that. It talks about the test necessary for that evidence to be admissible. And I think as a practical matter, for the evidence to be admissible, you can't start presenting that evidence and sort of prove up admissibility on the fly in a trial in front of a jury. And
Why not? That's how evidence almost always works.
Because there's more substance involved, I think, with the Denny decision, with the Denny type evidence, and that gets into the trial court decision here talks about springing this on the state, talks about the ability of the state to sort of investigate. And I think Counsel for Mr. Green says that this is just the court now bailing the state out. I don't see it as the court bailing the state out in this case specifically. I see it more as a commentary on why advance notice of this type of evidence is necessary, along the lines of an alibi defense or an insanity defense.
I can understand an argument as a matter of policy that this is a kind of thing where it makes sense to require notice. Whether the federal constitution allows that, I don't know. But I'm looking for a place where that rule is established. Suppose the state of Wisconsin were to repeal its alibi statute tomorrow morning. Would notice of an alibi still be required because, gee whiz, that would help prosecutors?
I don't think so, no. But I think
because it wouldn't be part of positive law anymore. And so I'm asking not for an argument about why the defense should give notice or why prosecutors think the defense should give notice, but where that requirement appears as a matter of positive law.
And candidly, Judge, as close as I can give you is State versus Wilson in 2015.
Okay.
Let me ask you a question on the discretion that the trial court judge exercised.
Yes.
It seems to me there's a real simple solution to this whole problem. The jury's out. It's lunch. Trial court judge seems to have that play into the manifest necessity in terms of, the evidence is seared into their mind. But why can't the judge just say, jury, go back home. We're gonna come tomorrow. And like anyone who's ever done a jury trial, you get all the jurors' info before they leave. Then you have this Denny hearing that apparently did happen later, and everyone decided it could be admitted. The judge. Shouldn't say everyone. I'm sure the state had something to say about it. But that could have happened. And it didn't. And I don't even see the judge weighing that option. So whatever standard of review I'm looking at, if the judge didn't even weigh the option of, guys, let's get this settled. Jury's out. We're having a hearing, and I'm going to decide. Because we know that hearing happened later, didn't take too long, and the evidence was admissible.
Right.
Why wasn't that weighed? And how do I look at it right now?
So as far as why it wasn't weighed, I think the court, if not explicitly, and I don't have a cite to the transcript specifically on whether it weighed it, but at least implicitly, I think what the trial court was getting at there is that the surprise, the introduction of the evidence did take the state by surprise.
It was on the witness list.
And sure. As far as, the state sending an investigator, I mean, this was one of the suggestions, that the state could send an investigator to talk to Mr. Cousin. Say, what are you going to testify about at your cousin's trial? And Mr. Cousin would have been well within his rights to say, that's none of your business. Leave me alone, go away. That alone isn't enough. And so sort of the affirmative clearance, because it is the defendant's burden to clear that Denny evidence in order to prove admissibility.
If there was such a burden.
Sure, but as proponent of that evidence, the defendant is in the position of having to prove its admissibility, which requires certain things to affirmatively be established, which would put Mr. Cousin on the stand at the hearing and giving his testimony in advance so that could be...
But every trial that goes on downstairs, whoever is admitting the evidence has the burden to show that it's admissible.
Right.
And for expert evidence, there's certain degrees. For there's relevancy. There's evidence sufficient to support a finding. But we do that in trial. You lay the chain. You have burden to lay chain of custody to a certain extent. There can be gaps, but that's done at trial. You don't show the evidence sufficient to support a finding pre-trial.
Sure, and
you'd never get to trial.
So where that comes from in this particular case is there was a motion in limine. It was never ruled on the record, but there was a motion in limine for this evidence to be disclosed in advance.
Is that what the motion in limine said?
Well, the wording in it's perhaps a little bit muddled because it refers to other acts evidence of a third-party perpetrator. And so, is that the clearest? No. And when we end up in this court on habeas corpus, often it tends to be closed cases. This is not, a case where everything was done perfectly in the trial court by the prosecutor.
We come back to a phrase like manifest necessity. I hope you're not arguing that by refusing to rule on a pretrial motion, a trial judge can create manifest necessity for a mistrial. The manifest necessity is my own refusal to rule on the motion.
No, Judge.
That's a slam dunk double jeopardy problem, right?
And that is, yes, and that's not my argument. My argument on manifest necessity, whether the trial court exercised sound discretion in declaring a mistrial, is this. They come back from lunch. The issue is sort of now presented on the record. There was 5 minutes or so of conversation off the record before, but the judge is sort of looking at this, and this is a judge who took over this case that morning and says, here's my concern.
That's the state's decision. If you substitute in somebody who doesn't know what he's doing, the probability of error goes way up. But it's hard to call that manifest necessity either.
But what happened, so while it's true that this is sort of the state court system and the system that I think most frequently gets used in Milwaukee County, I I think it's still reasonable for the trial judge in that situation to rely on the arguments of the parties. And Mr. Green at that time never argued that there was no pretrial order requiring disclosure of Denny evidence in advance. All trial counsel argued at that time was, well, this isn't Denny evidence, and of course it was Denny evidence. That's the only reason it could have possibly been relevant, is to prove that it wasn't Mr. Green who drove the victim on the night in question, that it was Mr. Cousin who drove the victim on the night in question. So the...
Wait. Are you now saying that Denny evidence is all evidence identifying another person? So suppose John Jones had gotten on the stand and said, I saw very clearly who the two occupants of the car were. They were A and B, and not Green. Would that have been Denny evidence?
Yes. That's evidence of a third-party perpetrator committing the crime.
No, it's not evidence that a third party committed the crime. It's evidence that the defendant did not commit the crime. It's not evidence that somebody else did.
I think that's two sides of the same coin, Your Honor. I think...
But on your view now, you are saying that the defense has to give all exculpatory evidence before trial, because all exculpatory evidence implies that somebody else committed the crime, because we know there was a crime, and therefore there's a general requirement that all exculpatory evidence be disclosed, including just a different witness says, I don't recognize Green as the person who did it.
Well, I think that's a different... I think would be different testimony. I think the...
Has the state judiciary ever said that the defense must notify the prosecutor about all exculpatory evidence?
No.
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 Absolutely not.
But testimony...
That would be, well, the word unconstitutional comes to mind.
And I'm not arguing for such a rule, Judge, but testimony that, and if I could complete my thought briefly, I see my time's up. Testimony that says, I saw what happened, it wasn't the defendant, I think is fundamentally different than testimony that says, I saw what happened, it was this third party. And I think that's what, the latter is what we're talking about in this case. So, if there are no further questions.
Thank you, Mr. Blumman.
Thank you.
Anything further, Mr. Wasilewski?
Just briefly, Your Honor, if I may. This court asked the state about any basis in law for prior notice being required under Denny, and I would just call to the court's attention that there's no notice requirement in either Denny or in the Wilson case, and in fact, when you read the facts of those cases, the evidence that was sought to be introduced came out at trial, and a decision was made during trial regarding the admissibility of the Denny evidence. So there is no judicial requirement for prior notice in either the Denny case or the Wilson case. A Denny hearing could easily have been done here, as Justice Kolar suggested. Mr. Cousin's testimony, he completed his direct examination. The prosecutor had completed cross-examination, and just before redirect, the court declared its lunch break. So the entire direct and cross were a matter of record when the parties met up after lunch and this whole issue was discussed. And it's clear from the record that the trial judge had the Denny case in front of him and was looking at it and talking about its holdings, and did everything except actually address the question of whether the Denny case allowed or didn't allow Mr. Cousin's testimony. That tends to show that there was no manifest necessity here. This could have been decided, and I believe the second dissent in the state Supreme Court case makes that point. The court simply never considered whether we could simply continue because the jury only heard admissible evidence. I have nothing further.
Thank you, counsel. The case is taken under advisement. United States against Diaz is our last case for today. Mr. Mitchell.
Good afternoon, Your Honors. May it please the Court, my name is Gregory Mitchell. I represent Mr. Jorge Diaz. Judges, I would like to start the presentation primarily with looking at the argument that I highlighted in my reply brief that I believe still hasn't been addressed. And that's essentially whether or not this grand jury statement is the type of statement that the court has recognized that has the type of particularized guarantees of trustworthiness that the hearsay exception should acknowledge. And I think in looking at the government's brief, I think it's telling on page 17 of their brief where they cite in Owens essentially what the type of evidence and statements and assertions that the rule allows. And they add in brackets or other testimonial statement, and then they add in brackets or statement, because the facts in this case raises the question, and I think Judge Coleman saw it at the district court, is whether a truncated statement prepared solely by the prosecution after several interviews with a co-defendant who is clearly involved in this case, and then submits that to the grand jury and now wants to represent that that is a voluntary, particularized statement by that person in the grand jury that should be given the kind of same trustworthiness of credit as if this person testified under oath, was asked questions by the prosecution, that the grand jurors who may have had questions may also could have asked questions, and then those testimony could be challenged if in fact they then began to change their testimony later. The real concern in this case, Judge, goes to the issue of the due process and the confrontation clause, because when you review the facts of this case, the government had everything on Mr. Diaz except one issue, and that was his knowledge about the conspiracy and the involvement from the very beginning. And they had evidence during the investigation that there was someone else in his family, his brother, who when they researched and they arrested him in his room, separate and apart from whether Mr. Jorge Diaz was, and found evidence to implicate him as being part of the conspiracy. And so the government was under this position right at the end of their investigation. How much could they prove that Mr. Jorge Diaz knew with respect to his involvement? And the way they got around it, and this is the problem that I had, the way the government got around it is that they began to interview Ms. Bonilla repeatedly over time, had her involvement, and then they prepared a statement summarizing a truncated statement about all of these different interviews to make sure that the statement that she would provide by the government would...
I didn't think we were here about the rule of completeness. Did you ask the district court to admit all of her testimony? To order the prosecutor to bring out all of her testimony?
No, Judge, and just...
Okay, so we're not here on a rule of completeness basis. We're here about the hearsay rule.
Yes, Judge.
And you really need to discuss the text of Rule 801 D1A.
Yes, Judge. And the text implies, as I point out in my brief, Judge, at 26, the implication of it is that there's some sense of trustworthiness as to why it should be...
It doesn't say anything about trustworthiness. It just says it's not hearsay if the witness is in court. That's what it says.
Because the statement
is... Not because. It has a rule in it. The rule is, if the witness is in court, it's not hearsay.
But 801 talks about what hearsay is, Judge, and the reason why the reliability is the crux of the whole hearsay exception and the rules. And so you can't simply look at the rule, in my opinion, given what the...
Why not?
Because I think the Supreme Court talked about it in I think it's the Idaho case that I cite, Judge, for you, Idaho versus Wright in 1990, where it kind of explains that you have to look at the text in the context to which this statement that is being offered as, so you can determine whether or not it has the indicia of credibility and trustworthiness to allow it simply to come in.
That's not what 801 D1A is about. There's a separate rule for especially reliable testimony.
And I think
Are you
said-
asking us just to merge them or to treat D1A as if it had vanished?
No, Judge, I want you to consider 801 D1A as part of 801, as essentially indicating that there is a premise that you have to essentially have someone to at least accept that this prior statement that was given in the grand jury was in fact their statement. They have to even acknowledge that it was their statement. And I think that's the language of the court's decision, is that the person essentially gave a statement prior and acknowledged that fact.
That's not in D1A either.
And I understand that, Judge. I do. And I understand, Judge Easterbrook, that we're looking purely at 801 D1A. But I don't think that the concept of applying the hearsay exception, you can simply ignore the whole basis of why it exists in the first place.
What would the limiting principle be there? Are we also going to say, okay, if we're admitting business records, are we going to look to see if those business records are independently reliable? Or is that just they come in and you get to argue what you get to argue?
I think, again...
I mean, if we're going to apply it to one exception, my point is, are we just applying it to every exception?
Well, again, 801 D1A is not an exception to the hearsay rule. It's the definition of whether it's hearsay or not. And the court has made a rule that says it's not going to be hearsay because it is fundamentally reliable.
Not because it was fundamentally reliable, because the witness is in court. Look, what you're arguing is that Rule 807, the residual exception, should be the only thing we look at, and that if something doesn't qualify to come in under Rule 807, it doesn't come in. We've been administering this set of rules for a very long time without trying to merge everything into Rule 807.
And again, Judge, and the reason, and looking at those cases that you applied, it clearly applies to statements that were given under oath in the grand jury that the person has affirmed they gave it. Not that there was a denial that it was ever a statement that they gave. Not that there was a denial that that affidavit that was submitted was not my signature. This is a situation where the rule sort of trumps everything else that we want in the adversarial process in terms of due process. Because clearly, the Confrontation Clause doesn't simply say that the person shows up at trial. They have to be willing to testify so you can have an opportunity to give a cross-examination.
We have considered and rejected that precise argument in earlier cases. And the Supreme Court statement of the rule has been, there is no Confrontation Clause problem if the declarant is in court. It didn't say anything about the declarant being in court and not truculent.
In my reading, Judge, I thought was prepared so they could be questioned and so that the challenge, which is the crux of the cross-examination, so it can be established, so that in fact you can challenge the credibility so the juries can weigh it. That's the whole point, that they have to be there. Simply being there isn't enough, as far as I can tell.
What Supreme Court case would you cite for that proposition? That simply being in court is not enough.
Judge, I think Owen sort of outlines that. And it talks about the opportunity to bring out such matters as the witness's bias. Owen talks about the opportunity to address these issues, not simply having someone's warm body in court so you can essentially say, well, they're here, and that's enough. I don't think that the language has to be where the rule says, this is what we mean by showing up, understanding that we're talking about the admission of evidence and statements. I see my time, Judge. I'll reserve that for unless there's questions.
Certainly, Mr. Mitchell.
Thank you.
Ms. Morgan.
Good morning, and may it please the court, Alexandra Morgan on behalf of the United States. The district court properly permitted the government to introduce Ms. Bonilla's prior grand jury testimony after she testified that she could not recall the events in question. The Confrontation Clause and the rules of evidence permit the substantive use of prior under oath statements, including statements made before the grand jury, just like the statement here. The exact format of Ms. Bonilla's prior under oath statement and defendant's argument that it wasn't in a specific question and answer format really has no bearing on this inquiry. What is important under Rule 801 is that the statement was given under oath and at another hearing or proceeding, which is precisely what happened here. And I'll also note that the parties here stipulated that the grand jury statement was Ms. Bonilla's prior grand jury statement as of a certain date. Along those lines, it is not relevant that Ms. Bonilla could not recall ever testifying in front of the grand jury or denied making the statement.
Has there been a diagnosis of senile dementia?
No, Your Honor.
Then why wasn't there a prosecution for perjury? I mean, this is obviously false testimony.
I think that's right. I think that's a fair reading that this was totally feigned amnesia. I can't answer the question as to why there wasn't a prosecution.
It's up to the executive branch. You're not answerable to us for that.
But I will say that on multiple occasions, this court has determined that that difference of feigned versus genuine amnesia doesn't matter to the inquiry. Ms. Bonilla took the stand. She was subject to cross-examination, and that provided defense counsel with the tools to attack her credibility before the jury, and that's exactly what happened here. In these circumstances, the Confrontation Clause and Rule 801 were satisfied. If there are no further questions, the government requests that this court affirm defendant's convictions and sentence.
Mm-hmm. Thank you. Mr. Mitchell? Seeing none, thank you, Mr. Mitchell. The case is taken under advisement, and the court will be in recess.